I have the first one is a motion to dismiss the father's petition as moot.
Right away, notice the tone. We're not just in a messy divorce anymore. This is a multi-year legal war that's older than some middle-schoolers. And trust me, when a case drags on this long, courts get less patient, more procedural, and way more focused on who's wasting the court's time.
Yes, Your Honor, we can start there. Just a nature of background for the court. This matter's been pending since 2019. We have a trial set in 2 days in front of Your Honor, November 5th, day after tomorrow. There are 3 petitions that are pending for trial. It's the father's petition for to modify child support and to terminate or reduce alimony, mother's petition for civil contempt for enforcement of the final decree of divorce for attorney's fees and costs, and then father's petition to enforce the parenting plan. Starting with the motion to dismiss father's petition as moot, as I said, one of the petitions is to enforce the father's parenting plan, to enforce the parenting plan.
And here's the first bombshell. The mother claims the parenting plan is moot because the kids are now grown. That means she's trying to close the door on anything involving custody or visitation. Why? Because if there's no parenting plan, there's no argument left for the father to seek changes that might affect financial obligations.
But there are no more minor children in this case, Your Honor. All the minor children have emancipated. The last one graduated from high school this past May. So child support has expired, and we just have to figure out how much it is. But at this point, we'd argue that that petition is moot, and there is no more. There's no longer a parenting plan for the court to enforce. Should I go on to the next motion, Your Honor?
You might.
Okay. The other motion is the motion to enter child support worksheets nunc-pro-tunc. So as you'll recall, Your Honor previously referred us to a special master hearing to resolve some of the issues that have been pending. We had the hearing. Both parties filed exceptions to the special master's findings. We had a hearing on those exceptions, and on February 12th, 2024, Your Honor entered an order which ruled on each party's objections and modified the findings of the special master. Your Honor modified some of the variables that were used to calculate father's child support obligation from February 2019 to June 2021. However, Your Honor's order did not include the new calculations or the child support worksheets that actually stated what father's child support obligations would be during this time. So for the order to be complete for that time period, we need child support worksheets to be entered that take the variables from the special master's findings and the ones that you modified and put that into the court's order. There are no factual issues left to be heard for those child support worksheets for that time period. It's just the actual calculations. And the first exhibit I'd like to enter, Your Honor, here's the child support worksheets that I attached to my motion. I believe
anytime a lawyer starts saying variables, calculations, worksheets, just know this: they're fighting over money, and someone's child support number is about to be recalculated, possibly retroactively. Retroactive changes can mean thousands owed or saved, and that's why every single digit suddenly matters more than the children ever did in these cases.
this takes into account all of the variables and pulls them out of the correct places and enters Mr. Bailey's child support obligation. Here are the variables that I used. I'd like to mark that as the first exhibit, Your Honor. This is the chart that was in the motion. And it's a lot of math and a lot of numbers, which I hate dealing with. I've tried to make it as simple and as digestible as possible. These were the periods, the time periods in that first column going down that the special master, Your Honor, ruled child support will be modified for. In the third column, I've listed where I'm pulling the individual variables from, either the special master's finding or Your Honor's order that modified the special master. And then I've calculated, listed the new child support amount that should be entered based on those variables. So I believe I've done it all correctly. I try to make it easy for Your Honor. Mark that as the next exhibit, please. Our final motion today is mother's motion for discovery sanctions pursuant to Rule 3702. Three of the issues remaining before the court at trial are the calculation of father's child support obligation from June 15th, 2021 through May 1st, 2025. Father's ability to pay during that period, and then father's present ability to purge himself of civil contempt by paying all the arrearages that will be owed to mother. To make these determinations, Your Honor will need to see evidence of father's gross monthly income pursuant to the child support guidelines and his finances from June 15th, 2021 to present. Father's gross monthly income in the party's last parenting plan order was entered in 2016 was $21,666.66 per month. Mr. Bailey's claim is that his gross monthly income has been reduced since that time, and that is the major crux of what
The mother says dad is deliberately hiding money using business accounts, sneaky transactions, and creative write-offs. This is a classic family court tactic called voluntary underemployment, basically accusing him of pretending to be broke. If the judge believes dad is faking poverty, the court can assign him an income whether he earns it or not.
Will be heard at trial. And mother's position is that father's intentionally reducing his income for these proceedings and is making it up elsewhere, like company credit cards, like income for stocks that he owns. The issue of Mr. Bailey failing to supplement his discovery responses prior to trial has already been heard once before Your Honor. To pass up a copy of this order. So on July 1st, 2022, Your Honor granted our client's emergency motion to continue the trial and continued the July 6, 2022 final hearing so that the court could hear each party's objections for the special master findings and, quote, so that supplemental discovery responses can be provided and both sides can be prepared. That's on the first page of this order. I'd like to mark that as the next exhibit, please, Your Honor. Now, after that, Your Honor entered another order. Pass this up to the court. In this, the order regarding motion for scheduling order, highlighted there at the bottom, Your Honor, ordered that thereafter the court shall schedule a final hearing on any remaining issues and the parties shall supplement their discovery responses 30 days prior to the future final hearing date. Mark that as the next exhibit, please. That's exhibit 4. So we've had a hearing where Your Honor has ruled that supplemental discovery is relevant and necessary, and we've had a hearing and an order saying that it shall be supplemented 30 days before trial. Rule 3702, Tennessee Rules of Civil Procedure, states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may take such orders in regard to the failure as are just, and among others, the following. A, an order that the matters regarding which the order was made or any other designated fact shall be taken to be established for the purposes of the action in accordance with the claim. B, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting that party from introducing designated matters in evidence. C, an order striking out pleadings or parts thereof. D, in lieu of, D is just for attorney's fees and an order of contempt. In lieu of any of the foregoing orders or in addition thereto, the court shall require the party failing to obey the order to pay reasonable attorney's fees and expenses. Rule 3703 of the Tennessee Rules of Civil Procedure states that a party who without substantial justification fails to supplement or amend responses to discovery requests as required by Rule 2605 is not permitted unless such failure is harmless to use as evidence at trial, at a hearing, or on a motion any witness or information not so disclosed. In addition to or in lieu of this sanction, the court on motion may impose other appropriate sanctions, and this includes those under Rule 3702 that I just read. So the last time prior to this morning that Mr. Bailey supplemented discovery responses was on July 12th, 2022. And that wasn't even a complete supplementation. That was just a tax return, 2022 pay stub, and a 2021 tax return. And the 2021 tax return was missing pages to it. Now, Father once again has failed to supplement discovery before trial. We're 2 days out. And this morning I received an email from Ms. Roberts' office that had, and it was an email from March of this year that was forwarded to me that had his March year-to-date pay stub and his W-2 from last year. No tax return, no information going through at least May when child support would have expired, and none of the other discovery that would be relevant in this case, like his business credit card statements that he's using to make personal expensive payments on, and no 2024 tax return, and no bank statements showing additional income, which is what we expect it'll show. So we've got the rules of civil procedure and we have your court's orders. Both of them have been ignored, and here we are 2 days before trial, again saying we don't have what your honors ordered them to turn over. During the 5 years that this case has been pending, we've consistently made requests that discovery be supplemented. Attached to my motion are, I believe, copies of 4 different letters from different years where we've requested supplemental discovery. We've been providing supplemental discovery as we've gone along pursuant to the court order. This case has been pending since 2019. I think this is the 4th time the final hearing's been set. And we're not asking for a continuance because we've already done that once. And we're asking instead that the court impose the sanctions pursuant to Rule 3702 and 3703. We're asking that the court do any or all of the following. It would be strike father's pleadings and award mother a default judgment, treating father's failure to obey the court order as contempt of court, imputing father's gross monthly income for child support purposes at the amount of that it was in the current order, the party's divorce. I believe that's $21,666.66 per month, and impute father with the ability to pay his court-ordered alimony and child support obligations from January 2019 to May of 2025. That's for the civil contempt allegation that's pending against him. And impute his ability to purge himself of civil contempt and award Mrs. Bailey her reasonable attorney's fees. Thank you, Judge.
Robert?
Your Honor, this matter originated with me filing a petition to modify child support back in the last day of January of 2019. An answer was filed to that petition alleging that there was no basis for a modification. There was no, and we had also requested to terminate alimony. That became moot when the mother's remarriage. And when that was addressed with the special master to some degree also. But there was no allegation of willful underemployment in the answer. Thereafter, counsel on behalf of Ms. Tara Bailey filed a petition for civil contempt alleging 4 missed payments. That was it, just 4 missed payments in 2019. There's been no amendment filed to that petition for contempt. So we're dealing on the contempt for 4 missed payments. Your Honor, when it was referred to the special master.
There it is. The defense strikes back. Dad's side argues. The special master already said he's not underemployed. Case closed. This is a legal strategy called using prior findings as a shield. If the court already ruled on something, you don't relitigate it. So now the battle isn't about income. It's about whether anyone is allowed to question it anymore.
One of the bases in question number 2 that was referred to the master, the basis for the reduction of the petitioner's income, including any evidence of the petitioner's voluntarily underemployment. that was sent to the master, and that was ruled on by the master. And the master found that there was no willful underemployment. So again, taking the master that there was no objection, the court addressed the objections that were filed in this. And the respondent's objections were, number one, the respondent objected to the master's finding of the petitioner's 2020 gross income. The master found that Mr. Bailey's income equated to $12,684 per month, but based on his W-2, it showed a gross income of $164,350, plus other pre-tax deductions of $12,138, resulting in wages of $152 or $12,684. Respondent argues that the child support mandates the gross income. Your Honor reviewed that, found that the pre-tax deduction should have been added back in, and Your Honor set his income at $164,350, or set his income at $13,695.83. We've already addressed the special master finding of willful underemployment, and it's wholly inappropriate to come back in when that was not raised in the objections, and Your Honor didn't reserve that. So again, my issue being is that in any issue, I'm going backwards with his arguments on any sanctions for discovery, Your Honor, it has found my client's income is $13,695.83 as far as the master's concerned. That's it. We don't dispute that. That's a finding of the master. There was no appeal taken from that. And so again, there's not a dispute as to additional discovery on either part. Your Honor's found that Mrs. Bailey's income to be based on $20 an hour, and Mr. Bailey's income is $13,695. And so we took that as a finding of the court pursuant to Your Honor's order, and that's the issue. There's not as far as what his income in 2023 and 2024 are, is really not relevant to this proceeding. There's been a finding of what his income is. And so all of my issues were addressed in the special masters on the reduction. The only issue that we have to present, as Your Honor did in the findings, raise the issue that we objected. The special master found and assigned 0 days to Mr. Bailey. He was not awarded under the parenting plan 0 days, but because of the issue that arose in the marriage and the mother not forcing the residential time, and my client, again, not forcing the residential time, Your Honor ruled that on the calculation of child support rather than on the master should be $365 and 0 rather than what it is. Now, I will point out, Your Honor, that was going to be an issue that was going to be argued, and why I do not want the motion to dismiss. We agree that all the children are now emancipated and 18 years of age, so there's no enforcement of that. But again, the parties in their marital dissolution agreement and the court order specifically stated, and they're contractually bound by the statement, that the child support shall not be modified. It's not just reduced as in the statute it says. The parties agreed. The parties acknowledge that court approval must be obtained before child support can be reduced or modified. So there is no pleading as to change the residential time. So again, I think Your Honor has to take into consideration that. But again, as far as the discovery responses are, I took it as res judicata, what your order said when it was filed on 2/12 of 2024. I did not take exception to it and ask for a reconsideration. I did not seek an interlocutory appeal, nor did the defendants in this case. And so Your Honor ruled what my client's income was, and that's what it is. So I don't think it's appropriate to come in and to ask and to relitigate the special master when it's already been adjudicated. So in our position, as far as updating discovery, that issue is done. I did not feel that there was a need to update discovery. We're not disputing that her income was set at $20 an hour, and my client's income was set at some $13,600 and some odd dollars. And I took that as the ruling of the court. Now, as far as their motion to dismiss our petition to enforce the residential schedule, we stipulate and agree that the children are all emancipated and have graduated high school. But again, that we file that and we reserve that issue on the ruling of what days should be afforded to my client. But again, Your Honor ruled in your special master's report that that's what it was. And we didn't take objection to that. And so again, now the calculations of child support, his request for the introduction of child support, these are the numbers that Your Honor used, albeit that the 365 and 0 days are reflected in his, but these are the numbers that the special master found. So again, the scenario being is, I think these are the numbers. This is what the special master found. And again, once we have the hearing on Wednesday, if Your Honor takes exception to it, but again, based on the special master's finding, my client's income was set from February of 2019 until December of 2019 of $9,156, which Your Honor ruled on that he was entitled to deduct the $4,000 alimony payment. At the end of November, the then Mrs. Bailey got remarried. So again, that $4,000 was not reduced for the month of December. And so that equated his income back up. Your Honor modified her income starting in 2020 to $20 an hour. And those are the numbers Your Honor ruled after the exceptions to the special master. And I think we're all stuck with those.
One thing, I don't have the special, I don't have Your Honor, at least I do, let me see here. One of the orders, in the order that Your Honor ruled on the parties' exceptions, one of them, and I don't have it in front of me, was the special master's finding as to a child support amount in July of 2021. The special master hearing occurred in June of 2021, and Your Honor said in the order that the special master erred in determining July of 2021 because that wasn't before him at the time. So I would argue, Judge, that everything is open since June of 2021 when we have had, Your Honor has heard the facts, or the special master's heard the facts on everything between February 2019 when this case started and June of 2021 when we went to the special master. Everything after that is open. The proof has not been put in, and that's what we're going to do at the trial in this cause. These children, the last minor child emancipated in May of this year, so we have a finite date where evidence is going to be submitted when Your Honor needs to make a determination on child support. I would absolutely disagree that.
Judge is clearly frustrated. Imagine spending years sending this case through a special master just for the lawyers to drag everything back and reopen it. The judge is hinting at something big. If these lawyers don't stop recycling arguments, she might force them back to the special master, a costly, time-consuming punishment. This is the courtroom version of "Don't make me turn this car around."
The June 2021 special master hearing established the parties' incomes all the way to May of 2025. That evidence wasn't available at the time, and now it will be.
So what was the purpose of sending them to a special master? Just to fix that one little period, and then y'all could drag it out for another 2 years, and then at that point in time, we're basically back where we are. But the other option is to send you back to the special master for the hearing because of the fact that I said, I don't do this very often. I referred it to a special master to determine those issues. Those issues were determined. We had a hearing on the exceptions, and all of that became fixed. Now it has been, my order went down in 2023, I think. It was actually February of 2024. And we're now over a year later, and the argument's being made, my order on the exceptions fixed everything as of that day. So now we're back here saying that, oh, well, we're going to reopen everything about the incomes and expenses and calculation of child support, which essentially means I'm going to be sending you back to a special master to cover all of those issues again, or else it was pointless to send you to a special master the first time. You understand what I'm saying?
I do, Your Honor. And I believe
We had the hearing, excuse me for interrupting. And we had the hearing immediately after the order was entered in February of that year. We could have tried to have it in July or whatever. Then it would have been a lot clearer. But now, essentially, reopening the proof to go into all of those same issues that were submitted to the master defeats the purpose of having a special master.
Yes, Your Honor. And we did not request that we go to a special master. We objected to that at the time, and and it doesn't matter now. But here we are. But I agree that the special master hearing only resolved issues that only resolved the proof up through the special master hearing. I mean, it's been 3-4 years since then, and situations have changed, incomes have changed, child support. I mean, all those variables are fluid, and Your Honor can see from the different sections that were presented, the different time periods of when child support had to be determined because the variables changed between February of 2019 to June of 2021. There's like 6 different child support orders there because variables change. And so the proof, now fortunately, I don't think there's going to be that many changes between June and 2021 now, but that proof hasn't been presented to the court yet. And that's all we have left to do. And the issue, the court still has to determine the contempt issue, civil contempt that my client filed. That issue was specifically not sent to the special master. And that would be from 2019 onward, those allegations of contempt. So that's where we are with that, Judge. 0 parenting days, that issue has been resolved, I would argue. Now, if there's been, I believe that Mr. Bailey would have the option to argue that he has since exercised parenting days to determine that calculation. But as far as the time frame goes from February of 2019 to June of 2021, I would argue that's the purpose of the special master hearing, and the exceptions and Your Honor's ruling afterward is those dates are closed. The proof during that time as to those issues are closed. Another point, something I'd point out, Judge, is that these discovery orders were entered after the special master hearing. So we came before Your Honor before and said we are going to need supplemental discovery. We're going to need to show his income for the period after the special master hearing. It's relevant. Your Honor agreed, granted our continuance, and ordered that the parties supplement discovery. That was done after the special master hearing. That was done. One of these orders is 2023, one is 2022. That's all I have.
Your Honor, again, on the issue of contempt, it is not ongoing. Petition for contempt states 4 payments. 5-1 of 19, 6-1 of 19, 7-1 of 19, 8-1 of 19. That's the only issue on contempt, as to whether or not he was willfully in violation of the court's order on contempt. The special master has already ruled that he was entitled to a reduction of $4,000 on the alimony paid during that period of time. And that should have been taken out of his income. So he was entitled to a reduction during that time. There are no, Your Honor, on the issue of contempt is simply on those 4 payments. Was he willfully in contempt of court? My client was ordered to pay an amount. he paid less than what he should have paid based on our calculations based on what he was entitled to. So that's the only issue of contempt before the court, nothing past that. And again, Your Honor, it was my understanding, again, when we came before the court on the first motion to continue, it needed to be bifurcated because you wanted to hear an order. You wanted to hear, and then after that, I asked for a continuance in the March hearing due to when I broke my leg and had to have both my leg surgery for my broken leg and my hip replacement. So that was the last continuance. But again, the issue being is thereafter the court shall schedule a final hearing on the remaining issues and the parties shall supplement their discovery responses 30 days before the final hearing. There's not anything to supplement. Your Honor found that this is what my client's income was, and we don't dispute that. Again, there's not been a supplemental filing saying that he's had an addition, that there's a 15% deviation from the time that we had this hearing. So again, Your Honor, it's the convoluted time frame that we've been through causes these issues, but it's our position that parties had 3 children. My client was due a modification because of the alimony, number 1, then number 2, his income. The income of voluntary underemployment or willful underemployment was litigated by the special master. The special master found an amount of income. Your Honor modified that amount. And so again, that's what's owed. And we need a final determination of what's owed. But there's not a contempt on that issue, Your Honor. The issue is on the 4 payments.
Jack, you have the final say.
Thank you, Your Honor. There is a contempt on the issue in front of you, Judge, because that hasn't been ruled on by anyone. Even if he's entitled to a retroactive modification, we believe it's going to show that he still didn't pay. He still owes an arrearage. So either he violated the order that was in effect at the time by voluntarily reducing his own child support amount, or if the court gives him credit retroactively for child support modification, he still violated the order. But that's not what we're here for today. That's an argument to be made at trial because that proof hasn't been put on, and Your Honor hasn't heard that yet. That's still pending. If going back to the discovery issue, if there was no discovery supplementation that was required or needed and income wasn't going to be an issue at trial, why did I receive an email this morning that had Mr. Bailey's 2023 or 2024 W-2 and his year-to-date income and through March of 2025? I think they're planning on submitting that to show child support and help the court calculate child support through May of 2025. But I would argue that that is not enough supplemental discovery. That is not all of his income. And just because, the income, there's been no proof offered at the court after June of 2021. We haven't received the discovery on that, and Your Honor ordered him to turn it over. That's the bottom line. It was ordered to. The rules of civil procedure say it's got to be, and here we are, and it hasn't been again. Thank you, Judge.
Well, this case has been pending for a very long time, as has been pointed out, and it's not a simple matter. And that's the reason that it was referred to a special master. The issues that were referred to the special master are set forth on page 2 of the special master's report. Those issues include the following. 1, calculation of the parties' respective incomes from January 30th, 2019 to present. 2, the basis for any reduction of the petitioner's income, including any evidence of the petitioner's voluntary underemployment. 3, whether alimony payments made by the petitioner were considered and included in the respondent's income or deducted from petitioner's income at any point. 4, calculation of child support from January 30th, 2019 to the date of respondent's remarriage, November 2019. 5, calculation of child support upon the eldest child's emancipation. 6, whether the petitioner is entitled to a retroactive modification of alimony beginning January 2019 due to a change in federal tax law. 7, whether the petitioner is entitled to a modification of child support, and if so, from what date. 8, whether the petitioner is entitled to a modification of his obligation to pay 90% of the uncovered medical expenses based on a reduction of income. 9, the total of any arrearages owed by the petitioner for alimony and/or child support. Those were the issues that were submitted to the special master. Then those issues resulted in a special master's report being filed, and we heard on December the 19th, 2003, the exceptions to the master's report, which were filed by both parties, and the court took the matter under advisement, and I issued my ruling on February the 16th of 2024. That was filed with the court on that day, and then there was subsequently a motion to set a bifurcated hearing and some other motions that were filed. This court has recollections of this case, but it's for me to be able to say that I can rule on any of your motions sua sponte today. It behooved me to review the entirety of the file and to make a ruling, but I'm not going to probably be able to do that until tomorrow or the next day. So you're set for hearing on the 5th. We will reconvene on the 5th, and I'll tell you what my ruling is on your motions, but I cannot give you a ruling. This is my first day back in Cheatham County. I've not had an opportunity. We've had 5 jury trials in the last month, so we have not had an opportunity. I've not had an opportunity to be in my office to work on matters under advisement. So I'm going to take this file with me, and I'm going to review it tomorrow, and hopefully I'll be able to give you some definitive answers in the morning on the 5th. But I can't do any better than that. So I will take these matters under advisement. I can tell you that, as I stated, when something is referred to as special master, is to determine those issues so that the court doesn't have to have a protracted hearing on all of these issues. To then reopen because of the delay these issues defeats the purpose of having a special master involved. So one option is send you back to a special master, which I'm reluctant to do because of the delay, for one thing, and because of the expense involved in it, and another. I'll look at these matters and I'll try to determine the best I can what the answer will be, and then we'll come back to you on the 5th. Hopefully, if I'm able to get an answer to your motions before the 5th, I will let you know by email tomorrow. Otherwise, it will be on the morning of the 5th.
Thank you.
Thank you, Judge. Do I need to prepare an order for today?
I don't think it's necessary until we see what I'm going to do.
Understood. Thank you, Judge.